Okay, can you guys hear me?
Loud and clear. Yeah.
Great.
As you're getting on,
Put us on mute.
need a haircut. I said, I'm never getting it cut again.
Who said that? Good morning, folks. We're having a few technical difficulties connecting with YouTube this morning, but we'll try to start as close as scheduled. Thank you. Good morning. Welcome to the Maryland Public Service Commission's administrative. Take two. Good morning. Welcome to the Maryland administrative meeting for the Public Service Commission for October 6, 2021. We had a few technical glitches this morning, so thank you for bearing with us. I'd like to first announce that we've launched a brand new website under the banner of MarylandEnergyChoice.com. That's MDEnergyChoice.com. It was designed to give our state residential utility, both natural gas and electricity customers, additional options in terms of shopping for energy supply. The Commission's goal is to make shopping for energy customers as easy as possible to find information on how to choose a supplier, and our new website does just that. Once you visit MDEnergyChoice.com, you'll be directed to two separate sites to either shop for electric or natural gas rates. This has been a policy of the state for the past 20 years, and we encourage all citizens to check out this website. Additionally, on this website, we have several new brochures available that explain the ins and outs of how to shop for a new supplier, the benefits of shopping, as well as some of the perils. We've had some concerns over the past few years with customers inadvertently signing up or experiencing some deceptive marketing practices by some unscrupulous suppliers. So we provide some information on what to watch for, questions to ask when you are shopping. We have meeting minutes approved from our last meeting on September 29, 2001. All in favor, please say aye.
Aye.
Any opposed? The meeting minutes are approved. Good morning, Mr. Secretary.
Good morning, Mr. Chairman. There are 8 items on today's consent agenda. Items 1 through 4 are between Verizon Maryland LLC and respectively FiberLight LLC, One Voice Communications Inc., GC Pivotal Access Point DBA Global Capacity, and GC Pivotal LLC. Items 5 and 6 are both from Neutral Tandem Maryland LLC, consisting of tariff revisions regarding 8YY access charge reform, and items 7 through 8 are also tariff revisions regarding 8YY access charge reform from respectively Level 3 Communications LLC and Broadvox CLEC LLC.
Thank you. Seeing no questions from the commissioners, I would move that with respects to item 1, 2, 3, and 4, that we approve the interconnection agreement amendment 10 days following a 30-day comment period unless adverse comments are filed. With respect to item number 5, I move that we accept the tariff provisions for filing with an effective date of September 1st, 2021. Sorry, September 30th, 2021. With respect to items number 6 and 8, that we accept the tariff provisions for filing with an effective date of July 1st, 2021. And with respect to item number 7, that we accept the tariff provisions for filing with an effective date of July 31st, 2021. The vote begins with Commissioner Herman,
Aye.
Commissioner Linton,
Aye.
Commissioner O'Donnell,
All right.
and Commissioner Richard.
Aye.
I vote aye. The motions are approved. Mr. Secretary, the administrative agenda, please.
Mr. Chairman, item number 9 today is a request from Baltimore Gas and Electric Company for approval to implement a smart charge management project. On this item for staff, we have Drew McCullough, Annette Garofalo, and Mikhail Spiegelman. For the company, Daniel Herson, Nekarbaro Goka, David Schatz, Matthew Mansfield, Doug McKeel, Christy Fleischman, and Joseph Piccarelli. And for People's Counsel, Frederick Hoover.
Thank you. Good morning, Mr. McCullough.
Good morning, Mr. Chairman and Commissioners. Drew McCullough on behalf of staff. On August 30th, 2021, the Exelon Joint Utilities, Baltimore Gas and Electric, Potomac Electric Power Company, and Delmarva Power and Light filed a request for approval to implement their Smart Charge Management Project. The joint utilities are able to conduct this project because of a grant received from the United States Department of Energy on October 1st, 2020. However, in order to complete the project and receive the Department of Energy's full funding, the utilities require funding from ratepayers as well. The utilities are requesting to use $745,000 of ratepayer funds split among the 3 companies in order to offer incentives to participants of the Smart Charge Management Project. The project will consist of 1,000 customers. The project will consist of many different offerings, one of which, for example, will give customers an incentive to allow the utility to control the output of their residential EV chargers. This will enable the utilities to ease the impact of EV charging at any time. Staff finds this project to be innovative, and it may provide insights which can inform how EV charging is managed in the future. Staff has also reviewed OPC's comments filed on October 4th, which request that the Commission defer approval of the funding in support of the DOE grant until the utilities submit their plan for the proposed incentives. Staff understands OPC's request, but would rather recommend that the utilities' request for funding be approved in order to receive the grant, but require the joint utilities to file their incentive structure with the Commission at a later date in order to allow staff, OPC, and other stakeholders to comment on the structures of incentives at that time. In summary, staff recommends the Commission accept the Exelon Joint Utilities request to approve the Smart Charge Management Project and require the joint utilities to file their completed Smart Charge Management Project plan with the Commission at a later date. Thank you.
Thank you. We'll next turn to Office of People's Counsel. Good morning, Mr. Hoover.
Good morning, Mr. Chairman, members of the Commission. Fred Hoover on behalf of the Office of People's Counsel. As was mentioned by Mr. McCullough, OPC filed a letter where we state that we do not oppose the funding in support of the DOE grant, but we would ask that the structure of the incentives and the level of the incentives be provided by the joint Exelon utilities so that it could be reviewed by staff, OPC, and then approved by you. I understand Mr. McCullough's comments regarding how this process should go forward. I guess it's our preference for a prior approval of these incentive levels. We would note that according to the staff's comments, 60 to 80% of the customers that are going to be part of this DOE grant program are residential customers. So we think we have a specific interest in seeing what the incentives are going to look like in comparison to other incentives that are out there. If in fact the process in order to access the money from the grant would preclude this prior approval, the suggestion that Mr. McCullough made is acceptable to OPC, but I would state that our preference would be prior approval by the Commission before this goes forward.
Thank you. We'll next turn to counsel for the company.
Morning, Mr. Chairman, Commissioners. Daniel Herson on behalf of the Exelon Joint Utilities.
I'm joined this morning by my colleague from the legal department, Doug Michael, as well as some subject matter experts. From the PHI team, we have Matt Mansfield, who's a senior regulatory specialist in operation analysis and strategy, and Nekabari Goka, who's the principal business program manager in strategic planning. And from the BGE team, we have Christy Fleischman-Gronke, who's our manager of strategic programs, and Joseph Piccarelli, who's a senior engineer in the strategy group. We're excited about this filing and what we're able to bring before you today. We're seeking commission approval to take advantage of what we believe is really a fantastic opportunity, which is to access approximately $5 million in federal Department of Energy grant funding to design and implement a smart managed EV charging project. This project, however, has defined stages and associated budget periods, and it has certain go, no-go waypoints in order to access the additional funds. And we are now at one of those waypoints and need commission approval of the program to access the additional grant monies. Just as an update, we're currently in the process of wrapping up stage 1 of the program, which was all federally funded and involved research and background analysis and initial program design. And now we're at this point where, in order to access the balance of the $5 million grant to finalize and implement the project, we need commission approval. And that's the request for approval that's before your honors today. Specifically with the request, we're asking for $745,000 in incremental EV program funding in order to provide certain incentives for customers to participate in the smart managed charging program. And some of that is for 200 level 2 EV chargers for fleet customers that we would see switching to electrify their transportation assets. Federal rules prohibit DOE funds from being used for rebates and incentives, so the Exelon joint utilities are requesting the additional funds as part of the utility's existing approved EV charging programs. This program involves a variety of smart managed charging components. We have some cybersecurity components, data analytics, EV charging access to those who currently do not have smart EV chargers, grid impact analysis, advanced modeling, and fleet electrification, among others, to bring benefits to participants, customers, and stakeholders, including valuable learnings that can be applied to the current suite of approved EV charging programs, as well as any future EV charging initiatives or EV policy discussions in Maryland. And as I think we tried to point out in the filing, managed charging is very important as additional EVs access the electric grid for charging batteries, and it becomes necessary to really carefully control demand on the electric distribution system, due in part to many EVs charging during the particular times of the day. Just a quick word on the filings that the stakeholder parties made. We reviewed staff's filing. We want to thank them for their analysis, and we're pleased that they're recommending that the commission approve the request. We also reviewed OPC's filing, and we do understand their concerns, but we do believe those concerns can be addressed without delaying a commission decision on approval of the current filing. Mr. McCall beat me to the punch, but I wanted to say that if approved, we're going to have to submit tariff filings at a later point to support the developed rebate and incentive structure. So when we make that filing, of course, OPC and staff will have the opportunity at that time to comment on those filings and participate in any hearing where the commission considers the filings. Delaying approval of the filing before you, as OPC suggested in their submitted comments, however, that would put the DOE grant at risk because the utilities would effectively miss the deadline for approval to access the grant funds for the next budget period. The other thing I'll point out is that DOE doesn't actually need to see the rebate and incentive design before approving the next budget period. They're actually only concerned about the program having the necessary number of participants, and they leave it to the grant recipient to design the particular incentives and rebates. So we don't actually need to submit those to DOE for approval. So with those comments, I'd like to say we just respectfully request approval of that incremental $745,000 in funding so we can continue participating in the DOE grant program and taking advantage of the $5 million in available grant monies. So with that, we're available to take any questions that the commission might have, and I thank you for your time and consideration of our proposal.
Thank you, Mr. Herson. I appreciate the Exelon Utilities looking out for these opportunities to leverage ratepayer funds with federal funds, and it looks like the ratio in this case is rather beneficial for the state's EV customers who wish to participate in some of these early adopter programs here. Mr. Hoover, you've heard the responses from Mr. Herson, Mr. McCullough, regarding the potential of what could happen if we delay approval, and that the commission will have an opportunity at a later date to review proposed tariff language. After what you've heard this morning, are your concerns allayed, or do you still seek that the commission defer approval of the requested funding?
Well, I guess I have a question first regarding some of the comments made by Mr. Herson in his suggestion that these incentives could be reviewed later on by staff and OPC. I guess the question I have there is, if there becomes some dispute regarding what those incentives are, if one of us has a problem with that, what impact does that have on the grant? Because I know I heard an earlier briefing on this grant proposal, and I know one of the important triggers is that collection of 1,000 customers in order to go forward. So I guess I'm wondering how some concerns that we may have about what the incentives are at a later date would affect the process for getting the 1,000 customers and meeting the other deadlines in the DOE grant.
Mr. Herson, are you able to respond?
Yeah, I'll probably also lean on Ms. Fleischman-Gronke and Mr. Piccarelli to supplement whatever I say here. But I hear what Mr. Hoover's saying. I think part of budget period 2 is the development of the incentives and rebates. And like I said, the DOE, they don't really care what the particular details of that are. That's really something that we can handle here at the state level and before the commission through the tariff filings. So I feel like personally there would be enough time to, if there was some debate about what those particular incentives might have to look like, we could handle that through the tariff filing and approval process, even if that meant, an extra week or two before it was considered at an admin meeting. So I don't really feel like OPC or staff should be concerned that they're not going to have an opportunity to weigh in on that. And again, it doesn't really impact DOE's approval of the program. It would just be how we end up recruiting the 1,000 or hopefully more participants in the particular program. But let me ask my colleagues if they have anything they want to add to my response.
Thanks, Dan. I'll chime in quickly. Good morning, commissioners. Christy Fleischman-Gronke with BGE. I agree with everything Dan indicated. The plan for budget period 2 is to start recruiting customers, and then we would begin the demonstrations in Q4 of 22. So we essentially have a year until we would be issuing those credits to customers. We will be wrapping up, our plans for designing the credit structure in the next few weeks, by the end of this year, and filing the tariff pages. Essentially how we'll be building the budget is, if approved for the $750,000, as mentioned, there's a minimum of recruiting 2,000 customers into the program, 1,000 customers the second budget period, and then another 1,000 the third budget period. So we would be dividing out, the pot of money we have with the customers we anticipate to enroll in the program. The minimum, again, is 2,000. We hope to have more than that. So we will set an upper limit, determining a credit structure that we think is enticing to customers to participate, but still having, an opportunity to enroll as many customers as possible into the credit program. So, let's say we set an upper limit of 5,000 customers, and then, determine the credit structure from there. If we did not get 5,000 customers enrolled into the program, then we wouldn't spend all of the $745,000, which would in turn lead to a lesser impact to ratepayers.
Well, let me make one suggestion. Since you say you're developing the incentives, maybe the solution to this is when they're finally developed and maybe before you officially file them, running them through the existing work group where there was already a presentation made about this grant proposal to maybe get some feedback early on. So in case there's any concerns that either we have or staff has, they can be adjusted before we get to a tariff filing where we have to make official responses and then have the discussion in front of the commission at an administrative meeting.
Sure, I can work with Amanda Besta to get on that calendar and review our suggested approach.
Okay, thank you. It seems as if we've allayed some of the concerns raised by People's Council. My colleagues, Commissioner O'Donnell.
Thank you, Mr. Chairman. I want to be clear. Mr. Herson so oppose this to the Exelon utilities, just to get it on the record. The utilities understand that should we accept today's filing and approve it, does not constitute or presuppose approval of any subsequent incentive structure or filing, and that we will take a de novo review of that filing when it comes to us for acceptance or disapproval. Is that your understanding?
Absolutely, Commissioner. We totally agree with that, and that was our expectation. We're just trying to get the commission approval today of the additional funding so that we can move forward to access the balance of the DOE grant. But absolutely, totally agree that we would have, the commission would have that opportunity to review those incentives.
Fair enough. I just wanted to get that on the record for the next round. Thank you.
Commissioner Linton.
Thank you, Mr. Chairman. Good morning, everyone. I just had a question for the companies. Thank you. The companies, through their own independent efforts, have regularly made public statements promising to include and incorporate issues of equity in any EV-related programs that they would roll forward with. So I understand a lot of the details in this program haven't been fully flushed out yet, but could the company at least confirm for us on the record today that they're going to continue honoring the public comments they've already made regarding issues of equity for programs related to EV?
Yes, Commissioner Linton, thank you for the question. I would agree with that statement, and we can confirm that. I believe we have tried, at least in good faith, with every aspect of our program to have a material equity component to it. Let me again lean on my colleagues to see if they want to add anything in particular about this program. But I can say at a general level, yes, we would certainly strive to continue meeting those equity concerns and challenges as we design these programs.
Thanks, Dan. I can chime in again. So I'd say absolutely yes. We have a component of this program where we're working with a company to develop a smart charge adapter. So for customers that maybe didn't make the purchase of a smart charger, those charging stations are more expensive up front. They could still participate in this program by getting an adapter that we would provide through this program at no cost, and they would be able to participate in the incentives. We'll also continue to seek opportunities to engage with low-income customers. And separate from this DOE program, we have another DOE program for the Mid-Atlantic Electrification Partnership, where we've partnered with Lyft to provide the 100 electric vehicle rideshare cars, and those are targeted specifically in low-income areas. We are installing charging stations to support the recharging of the rideshare vehicles within Baltimore City through paths that Lyft has identified are most commonly taken from beginning of rides and ending of rides in low-income areas. So supporting that program with installing charging stations to support the recharging of those 100 vehicles.
Okay, thank you very much for the response. I think this is pretty innovative programs. Appreciate it. Thank you. Thank you, Mr. Chairman.
Thank you. At this point, I would move that we accept the company's request to approve the Smart Charge Management Program. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
All right.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Thank you very
Mr.
much.
Chairman, item number 10 on today's administrative agenda is a proposed delivery interconnection agreement between Washington Gas Light Company and the Washington Suburban Sanitary Commission. On this item for staff, we have Benjamin Baker, Neguse Tesfaye, Lloyd Spivak, and Kenny Albert. For Washington Gas, Paul Buckley, John Dodge, and Craig McKinnon. For Washington Suburban Sanitary Commission, James O'Day and Robert Taylor. And for Office of People's Counsel, Joe Cleaver.
Thank you. So we have 4 parties. We will begin with staff. Good morning, Mr. Albert.
Actually, Commissioner, I will be taking it.
Mr. Baker, good morning.
No worries. Good morning. Good morning, Chairman and Commissioners. Benjamin Baker on behalf of staff. I'm joined by Neguse Tesfaye, Lloyd Spivak, Kenny Albert from staff. On June 30th, 2021, Washington Gas and Light filed a special contract that it executed with the Washington Suburban Sanitary Commission. The contract provides for WGL to deliver natural gas to WSSC's facilities and for WSSC to deliver renewable natural gas into WGL's system. The contract is 18 years in length and can be extended in 5-year increments. The contract is currently structured to only permit a limited flow of RNG annually onto WGL's system so that WSSC can monetize the renewable aspects of the RNG. In all other instances, the RNG will not enter WGL's greater gas system. And instead will be looped back on to WSSC for their own consumption. Therefore, WSSC will pay for RNG for total gas net of RNG delivered to WSSC. And the parties may enter into a separate agreement in the future if this is to change. Staff recommends approval of the contract subject to 6 conditions, which are listed on pages 2 and 3 of our comments. WGL filed comments in support of 4 of these and has requested modification to 2 of the requirements. These 2 requirements are numbers 2 and 4. I will address 4 first, as staff agrees with WGL. Staff requirement number 4 requires WGL to notify the Commission's pipeline safety manager if RNG limits are exceeded in the contract. WGL asks that this be a quarterly report and not an ongoing report. Staff meant for this to be an annual report, as is required of BG&E and its RNG tariff, which was approved August 25th, 2021. So therefore, staff modifies its recommendation to be the company shall notify the Commission's pipeline safety manager on an annual basis if the following limits in the special contract are exceeded. Now to address requirement number 2. Staff requested that WGL track O&M costs, both shared and incremental, other costs being paid through the negotiated rates, and other miscellaneous costs caused by this agreement, and report this information in future rate cases. WGL has requested this be reworded such that WGL will track and report in future rate cases incremental O&M related to the RNG interconnection and monitoring, as well as if paragraph 4.4D of the agreement is invoked to generate separate invoicing of incremental cost. WGL argues staff's current proposal will be burdensome and likely impossible to comply with. Staff would like to explain why it has made this request. The contract is structured such that WSSC covers the near and long-term capital costs associated with its services. This leaves 3 different sets of costs which are part of staff's requirements. 1, incremental O&M costs driven by WSSC. 2, system costs that are supposedly covered by the negotiated rates. For example, those that would have been allocated in a cost of service study. And 3, costs that will only occur if something happens outside of expected operations, such as the bottled gas provision of the contract. So when examining the rates, staff did not receive a detailed analysis of how the final revenue is arrived at. And so that was the impetus for making sure that these rates going forward are covering their cost. So for shared cost, staff would expect that WGL would make available to parties in rate cases the WSSC portion of its system cost that would traditionally be allocated through its cost of service study. For incremental O&M directly attributable to WSSC, WGL, when we were doing our analysis, was not able to state definitively what those costs may be because those costs had not been identified yet. It is these incremental O&M costs that staff expects WGL to track, which may be greater than those associated with the activities by WGL's engineering department to support the services that WGL will provide to WSSC. But staff does not believe these costs are those that would be traditionally allocated, such as overhead cost. As stated, the company was unable to provide a specific incremental cost or the customer's allocable cost to prove definitively that WGL will earn its rate of return from WSSC. WGL's expected revenues from WSSC are also not cost-based, but appear to be based on negotiations. Staff believes customers are adequately protected under the current terms for the reasons listed in our analysis, but would like this information to be available in base rate cases to ensure the contract is not causing inappropriate cost shifting amongst ratepayers, which is not permitted by the Commission's rules for special contracts. And then finally, for those costs associated with events triggered by provisions in the contract, such as bottled gas service, environmental remediation, or system damage due to RNG, staff believes those costs should be tracked. Staff identified them as the miscellaneous portions in our recommendation, which would only occur in certain scenarios, and we discussed those on pages 12 to 16 of our comments. Staff's view is if a unique provision is triggered, the costs associated with the event can be reviewed at a later date to determine what appropriate cost recovery is. If costs are not tracked for these provisions, it is not clear how a resolution would be reached during the review phase. OPC filed comments that a number of these costs should be tracked, but also proposed remedies. While staff would likely agree with some remedies, staff believes these issues should be judged in the future based on the situation if the provision is triggered, instead of proposing a solution now. Staff believes with these clarifications, it is clear that the requirements in number 2 are not burdensome, but are simply there to ensure the appropriate information is available to parties to evaluate the ongoing appropriateness of the contract and recovery of future cost. Staff also reviewed OPC's comments, and it is not clear to staff what WGL's overall opposition to OPC's request to track incremental cost are. OPC is requesting that WGL track incremental costs to demonstrate future rate cases that the costs are less than the revenues received under the agreement. The only difference between this recommendation and staff's recommendation number 2 is that staff is not requiring a demonstration in its requirement, but making sure the data is available for review. Staff would assume most, if not all, the incremental costs from this contract are supposed to be covered by section 4.4 or other sections of WGL's contract, such that WSSC would be charged for those costs. If it is determined from this analysis that the negotiated rates fail to cover costs, such that other ratepayers are inappropriately being charged, then staff would expect there to be a discussion of disallowances that the Commission can judge at that time based on its rules for special contracts. For these reasons and those stated in our comments, staff recommends the Commission approve the contract subject to the conditions recommended by staff on pages 2 and 3 of its comments. Thank you, and staff is available for questions.
Thank you, Mr. Baker. We'll hear from Washington Gas at the appropriate time, their response to your condition number 2. We'll next turn to Office of People's Counsel. Good morning, Mr. Cleaver.
Mr. Chairman, Commissioners, can you hear me? I know I've had some volume issues with WebEx in the past.
We can. It's not the best, but we can.
Okay, I'll try to speak up, Your Honor. I apologize. It seems to be limited to WebEx, and I can't figure it out. Good morning, Mr. Chairman, Commissioners. Joseph Cleaver on behalf of the Office of People's Counsel. Your Honors, I was a little surprised to see Washington Gas's comments and the tone of them last night, primarily because OPC doesn't oppose Commission approval of this agreement. OPC, when we got the agreement, we were provided with a slideshow from Washington Gas, which we appreciate. We received the agreement, we reviewed it. We asked a number of discovery questions of Washington Gas, and Washington Gas answered our questions. After reviewing the agreement and reviewing the discovery responses, we concluded that we agreed with Washington Gas that this project appears to meet the requirements of General Service Provision 14 in that it appears to be revenue positive. And we also agreed that the rates appear designed such that existing customers won't be burdened by this agreement. But that said, we identified a few areas of concern, and for those particular areas of concern, we proposed some very narrowly tailored either reporting requirements or in a few instances, standards going forward, conditions that we think should be attached to any commission approval of the agreement. It's 4 issues, four proposals that we have in our comments, Your Honor. I'll walk through them and I'll try to be quick. The first is cost tracking. As Mr. Baker just pointed out, this OPC's proposal is similar in many ways to staff's proposal, and in fact, in one significant respect, it's actually more narrow than staff's proposal. In its comments filed Monday, OPC recommended that the commission require the company to track incremental costs and to report them in a rate case so that we can ensure that those costs are less than the revenue received from WSSC. Staff's recommendation is actually a bit broader, and I'm not bringing that up to disagree with staff, but it's a bit broader of a recommendation that says shared and incremental costs. So OPC's proposal in this regard is actually somewhat narrower. To be clear, OPC is not proposing any kind of automatic termination, as Washington Gas seemed to infer, in the event that costs exceed revenues, and OPC is not proposing any sort of automatic disallowance that would occur in that event either. But as Mr. Baker alluded to, this commission has standards for special contracts, one of which is that they won't permit excessive rate increases for other customers. And in order to ensure that that standard of the commission is met, we've proposed that when Washington Gas files a rate case, it provides the incremental costs and the revenues under this agreement so that we can look at that and then make whatever recommendation that we believe is appropriate, and then the company will respond as it deems appropriate, and then the commission will decide. The second proposal that OPC makes in our October 4th comments concerns reporting on leak rates in the immediate vicinity of where this new type of gas will be injected into the system. As we mentioned in the comments, this filing, it does evoke case number 9035, which is the last time Washington Gas injected a new type of gas into its system. And that issue was not only limited to case number 9035. We've seen that issue carry over in many other dockets, rate cases, stride proceedings, and even in case number 9622, where that was cited as the reason for the failure of the company to replace its mercury service regulators. That was a major problem with long-lasting implications that have spread over decades. With respect to this gas, we're hopeful that nothing like that happens, and in fact, it doesn't appear likely that it will. As we mentioned elsewhere in the comments, the amount of RNG that's being introduced in the system appears to be minimal, at least under this current iteration of the contract. But in light of Washington Gas's history, and in light of the response that it provided in discovery when we asked about who will cover the cost of any damage to infrastructure from RNG, Washington Gas's response seemed to indicate that all customers would pay for that damage. We've proposed a very limited idea for tracking any leak increases in the immediate vicinity. The proposal is limited to Strip 29, which is where this facility is going to interconnect to the Washington Gas system, and mains coming off of Strip 29. The proposal is also limited to 3 years and 6 reports. OPC's concerns that may seem unlikely, overly cautious, but I'd submit, Your Honors, that had you received a similar proposal in 2003 before that LNG was injected into the system, those would have been met with the same critiques. If Washington Gas wants to propose some other method to establish a baseline for leaks in the vicinity of the injections, we'd certainly be willing to consider that. But the comments last night didn't do that. They didn't propose an alternative way to allow parties to make that determination. Rather, they just rejected the concept outright. With respect to the third issue, this is the bottled gas issue that staff also raised in its comments. OPC did not propose any disallowances here, but OPC simply proposed that the costs associated with the provision of bottled gas under the agreement should be tracked and reported, and that the commission should be notified in the event that the company has to resort to that method of providing commodity to the new facility. There were a number of provisions in the contract that could potentially lead to some incremental cost. We focused on this one simply because we've seen with Washington Gas and other utilities too, delays in construction over the years. And so in the event that this particular incremental cost is incurred, which seems maybe more likely than some of the others that are set forth in the agreement, we would want to know about it. We think it'd be appropriate to report it to the commission, and we'd want it tracked and reported, so then we can make, again, whatever recommendation we believe is appropriate the next time the company comes for a rate increase. The recommendation in this regard is consistent with this commission standard for special contracts, specifically the first prong, which is that any special rate should recover customer-specific variable costs. The contract appears to be consistent with that standard of the commission, section 4.4D. I'm not going to read that because it's confidential, but section 4.4D of the contract does appear to be consistent with that. When staff asked the company in discovery for an accounting of incremental costs, the company responded that there is no estimate, and that Washington Suburban Sanitary Commission will be charged as soon as practical when or if they occur. So the response that we received last night to this proposal from Washington Gas, that, quote, OPC's comments suggested other customers would be entitled to the incremental revenues from WSSC while not bearing the responsibility for the incremental costs. Frankly, I'm confused by that. That response seems to suggest that other customers would bear the incremental costs, which seems to be in contradiction of the agreement of 4.4D. Finally, Your Honors, the fourth thing that we proposed was a prohibition on the recovery of any environmental remediation costs that Washington Gas incurs, only falling under section 5.8 of the agreement. This is, again, consistent with our other recommendations, a very narrowly tailored and limited recommendation. There's claims that this is somehow illegal, unconstitutional. Your Honor, there's no basis for that. The company's here before the commission asking for approval of a contract. This commission can condition its approval in that respect. And again, the recommendation from OPC would only apply to costs incurred pursuant to section 5.8 of the agreement. And if Washington Gas were to incur costs under that provision of the agreement, what that would mean is that Washington Gas had stored, leaked, spilled, deposited, conveyed, or released environmentally hazardous substances on either its facilities or on the WSSC facilities. So I think there'd be a basis to deny, I believe, any claim anyway on the basis of imprudence. But as an upfront matter, this is a uniquely new risk that Washington Gas will face. It may bear indemnification under that provision. As we mentioned in the comments, Washington Gas is going to be, through this relationship and through that provision, Washington Gas essentially links itself to the operations of wastewater treatment plant. That is a new type of environmental contaminant. And to the extent that Washington Gas became liable for any such costs under the agreement, there would not be any basis to recover those from existing customers. Your Honors, I would also point out that we cited Public Utilities Article Section 4.2.11, the section governing recovery of environmental costs. I would simply point out again that when the legislature passed that, it made that discretionary. It doesn't require the commission to ever include environmental remediation costs and rates. It says that the commission may. Also, as to the claims of constitutionality, I would point out to the commission that Maryland's Court of Special Appeals has rejected an argument that A refusal to permit a utility company to recover remediation costs is a violation of the Maryland or the U.S. Constitution. That's at 224 Maryland App 575, pin site 589 to 90. That's Columbia Gas versus Maryland PSC from 2015. Your Honor, in sum, OPC, again, does not oppose the Commission's approval of the agreement, but conditions its position on the Commission's adoption of OPC's recommendation, which are designed to protect customers from new risk from this agreement. Thank you.
Thank you. Most contentious exchange for a proceeding on which OPC is not opposing approval of the agreement. We will, before we turn to the utility, does the representative from the commission wish to make any response? The Washington Suburban Sanitary Commission.
Good morning, Mr. Chairman and Commissioners. My name is James O'Day. I'm Associate General Counsel 2 with the Washington Suburban Sanitary Commission. We're just here in support of the approval of this contract. It's a very important component and the next component in a very significant and important project to our agency. It has a lot of benefits, and therefore we urge your approval, and that would be subject to whatever resolution the Commission wishes to make with regard to the various exchanges about the conditions proposed by staff and OPC. I'm here to answer any questions I can answer, and I have Robert Taylor from WSSC, who is our energy manager, who on technical type questions would be more appropriate, but we're available for any assistance and question answering that your commissioners might need.
Thank you. I should also note that in the record, we do have a number of letters from officials in both Prince George's and Montgomery counties expressing support for this agreement. I'll now turn to counsel for Washington Gas Light.
Thank you, Your Honor. Paul Buckley on behalf of Washington Gas. Is the audio adequate?
Yes, sir.
Okay, thanks. Again, good morning, Mr. Chairman, Commissioners. Also with me today is John Dodge and Craig McKinnon. Mr. McKinnon is our project manager from the engineering division and has been involved very deeply in the planning and will be overseeing the construction. So if technical questions arise, he'll be of assistance. But given the issues that have been raised by the staff and People's Council so far, I think probably not. I would like to start out by thanking the WSSC. Even though we're going to be getting into a whole lot of inside baseball discussion of cost recovery, protection of customers, things of that nature that the commission deals with every day, I don't want the commission to lose sight of the fact that the WSSC is proposing a very innovative and important project. And Washington Gas is very proud to play a supporting role in that. And as you can tell from the letters of support from the councils of Montgomery and Prince George's County, they're eager to provide the financial support and see it come to fruition. But with that, now we're going to turn to a whole lot of the inside baseball. If at some point in time during the discussions, we need to go to some of the confidential material, the WSSC individuals are prepared to drop from the call. So I just wanted to offer one last time, if any of the commissioners had questions directly for the WSSC before we get into some of the competitively sensitive information. And
well, Mr. Buckley,
yes,
I would prefer that we don't get into the confidential information, and I don't know if we will or not at this time. We are streaming live on YouTube, so it'd be more than just getting WSSC out of the room.
Understood.
Everybody in the United States could possibly be watching right now, but I know that's not the case.
Only half full.
Let's for the benefit of the commissioners, or at least my benefit, I think it would be best if you could take the issues raised by Mr. Baker, which is with respect to condition number 2, and then we'll go through Mr. Cleaver's concerns. So that's 1, 2, 3, and 4. You don't have to go from scratch. We read your response that you filed last night. I do concur with Deputy People's Counsel Cleaver that the tone was a little bit harsh. in response to a pleading that they signal that they are in agreement with. But if you could organize your notes or your statement in such a way that you're responding to both Mr. Baker and Mr. Cleaver, I think that would be helpful to us.
I can, and I think I can adequately do that. But let me address the tone of the response first. Although People's Counsel is in support of the project, Your Honor, they are proposing changes to both the Commission's rate making and line extension policies that have been in place for decades. So, in the sense of the fact that they haven't opposed a project, they are nonetheless putting at risk cost recovery from the company in a number of very important elements. And I thank Mr. Cleaver for his clarification on the if there would be a failure in his eyes to see that incremental revenues covered incremental costs, that it wouldn't put the WSSC project in jeopardy. But it wasn't clear from their initial comments. But Your Honor, it is, from the company's perspective, almost inappropriate that when we're talking about whether a contract is adequately protecting customers, to seek to change decades-long principles that the Commission has abided by in administering special contracts. So with that, I'll go to the specific issues that have been teed up by the staff and People's Counsel. The first one relates to track costing. And also, I'd like to thank the staff for their agreement to modify Condition 4. That will be of great assistance to our engineering staff in terms of providing reports, and it still will provide meaningful information to the staff. But with relation to Commission staff, Condition number 2.
And just to be clear, Mr. Buckley, I think we were talking about Condition 5 is the annual report, not Condition 4.
It was Commission. It was number 5. I believe Mr. Baker called it 4. I didn't know if his enumeration was different than what I had in our comments. But
right, I think Mr. Baker misspoke, or at least according to my paperwork. But yes, number 5. Okay, thank you.
Thank you. So, Commission Condition number 2, which does overlap in some sense with People's Counsel's condition, although Mr. Cleaver is correct that the staff one is broader. We have some challenges with this. So from the very beginning, the way that the condition is worded, it truly would be impossible to comply with. There are allocated costs, and I heard Mr. Baker say they aren't targeting allocated costs, but the wording of the language does. It is asking us to track all changes in cost as they impact the WSSC. So putting aside, building costs, existing pipelines, Mr. Jenkins' salary, and those things, talking about the incremental measures. Washington Gas has never been asked or tasked with tracking the cost of any specific customer. And that's for a good reason. It's very challenging and difficult. The company has 1,500 employees. To track the cost of any employee interaction with any particular customer would involve writing a process and procedure and educating all of those specific employees.
Mr. Buckley, can I stop you right there? I
Yes.
don't think that's what Mr. Baker is asking for in this condition. Perhaps you could read into that, but Mr. Baker, can you respond? You're not expecting the utility to allocate the costs of each of its 1,500 employees, are you?
No, that was not the intent. I think the way we were viewing this is, if you believe that our understanding is that the rates are supposed to cover what the costs are that WGL thinks it has today. And then if there are supposedly what they would call incremental cost, then those are what should be, what we're, I believe, deeming needing to be tracked. I think there is a shared component to our recommendation that we are asking for, but I think the way we said tracked is probably not the appropriate way of viewing it. That's more or less, we want to be able to look at how shared costs are allocated in a rate case, but that doesn't require tracking so much as the ability to have the information available such that you can look at if this customer was a customer within the cost of service study, how those costs would be allocated to them. But that's not a track. I don't view that as tracking so much as please have the information available for parties to look at. Does that clarify or help?
It does for me, Mr. Baker. I want to hear from Mr. Buckley because I know the term tracking, and you spent some time on this on your pleading yesterday. It's obviously a defined term of art here. Mr. Baker concedes that that was not staff's recommendation. Mr. Cleaver may have something to say about this as well. And perhaps, Mr. Buckley, do you have a proposal aside from the one you presented last night? Or maybe staff could come up with a proposal on the fly that would alleviate some of the utilities' concerns here. Because I agree with you, Mr. Buckley, it would be nearly impossible if you read to the letter of staff's recommendation here to accurately account for all these costs.
So the clarification is helpful, Your Honor, and thank you, Mr. Baker. So that clarification is helpful, but I still believe it would be manageable if the tracking of the incremental costs were limited to the engineering interactions with the WSSC. So as you might expect, numerous business units of the company interact with all of our customers on a daily basis, whether it's billings, meter readings, fleet vehicles interacting. There's just numerous instances. I think the focus of what the staff wants to understand is, are there any cost drivers during the administration of this contract that's unique to the WSSC that the commission should be apprised of and that the staff could take action on or comment on in a future rate case? And the company believes it would be manageable if we limited it to those engineering interactions of the RNG interconnection and the gas quality monitoring, which are very unique to the WSSC and different than any interaction we have with any other customer. So we think that would provide the information that the staff needs, and we believe People's Counsel as well. All of the other interactions are ones which are routinely allocated, and they would not need to be tracked. So the language we proposed as the alternative, we believe would meet the staff's needs, perhaps not in the full extent that Mr. Baker would like, but I think it will provide them with the information that from future rate cases, they could offer comments.
Thank you, Mr. Buckley. Let me just say this is a little more complicated than what first met the eye. So we're going to take these issues one at a time, starting with cost tracking, which both staff and OPC had concerns with, and then allow commissioners to ask questions. Mr. Baker, if you want to get back in and respond, just raise your hand. Mr. Cleaver, if you wanted to respond to see if any of Mr. Buckley's clarifications addressed some of your concerns. I think we were talking past each other earlier, or at least in pleadings, we obviously were.
Thank you, Your Honor. Appreciate the opportunity to weigh in. I guess as I'm listening to Mr. Buckley and I'm looking at the agreement, and again, I believe this is a confidential part of the agreement, so I can't read it, but it appears to narrow 4.4D of the agreement. I don't know how you can comply with 4.4D of the agreement without doing something along the lines of what staff and OPC have asked, without the further limitation. And then also there's this data response to staff 2.2. I think that was included with staff's filing. So I guess maybe it might make sense for Mr. Buckley to explain that, how what he's proposing it does not narrow 4.4D and how it's consistent with what was stated in the company's response to staff DR 2.2.
Yes, Your Honor, if I might, again, without going into the language and to give the commission a full flavor for this, I would recommend, if we still have challenges in understanding the more general launch of concern from People's Counsel and staff about whether customers are adequately protected, that at the end of our discussion, we go into closed session and we can summarize those protections, which are far more robust than I've ever seen in any other special contract. And Washington Gas has 5 or 6. And from my prior public service, I had access to Western Maryland and Central Maryland contracts. This is far more robust. But in specific to the contract clause that Mr. Cleaver is making reference to, if an event occurs that triggers that clause, then the company will be aware of it and follow suit on it. There isn't a need for instituting extensive accounting protocols and tracking of items. It would, so to put into context, and with Mr. Taylor and Mr. O'Day still here, they are aware that the gas quality monitoring is a very elaborate automated arrangement, which is being constructed and administered by Mr. McKenna. If events change such that the company would need to start doing manual intervention with that and have manual monitoring, that's the type of incremental cost that we are agreeing with the staff that we'd be happy to provide them notice of. That's such an out of the ordinary event with this contract. What we're hesitant to agree to, and we believe the staff and People's Counsel language goes to it, is they want tracking of all of the ordinary costs that occur with the customer. And that is the unduly burdensome and quite frankly, impossible aspect that we couldn't do. I'll make it clear.
Mr. Buckley.
Gas, just one last point. Washington Gas has never tracked individual costs for a customer. So it sounds easy, but to administer and create those accounting policies to capture them well, it is a very large task, and so it should be limited in nature.
Thank you, Mr. Buckley. I attended a utility conference recently where they the motto of this particular utility in Maryland is nothing is impossible. However, at this stage, it appears clear to me that the parties haven't had offline discussions regarding this. We appreciate our friends and colleagues at the WSSC for moving this project to where it is today. I suspect that commissioners don't have any detailed questions regarding the project. And as you noted, Mr. Buckley, we're more focused on the inside baseball regarding these 4 issues at hand, particularly the issue that's most concerning to both staff and OPC is the cost tracking issue. And then OPC has its separate additional 3 issues. I don't think it's going to be a valuable use of the commission's time this morning to proceed further on hearing the arguments in this case. I believe, and I think I speak for my colleagues, that there may be some additional room for compromise. It's clear this morning that all 3 parties were not exactly on the same page with respect to either intention or expectation with respect to cost tracking. So I'd like the parties to speak offline, perhaps meet later this morning, figure this out, come back to the commission 1 week from today, October 13th. We'll put this back on the administrative meeting and hopefully the parties could resolve some of these differences or at least get on the same page with respect to understanding it. There's still a dispute. We'll resolve it at that point. But nothing further on this item. Mr. Secretary, please call the next item and schedule this item number 10 for next week's AM.
Yes, Mr. Chairman. Mr. Chairman, the final item today is item number 11. It's an application for construction of a water system from Artesian Water Maryland, Inc. On this item for staff, we have Jim Greger, Samuel Tete, Lucy Shea, and Ben Baker. For the company, Scott Steffen, David Spack, and Joe D'Annunzio.
Thank you. We'll begin with staff. Good morning, Mr. Greger.
Morning, Mr. Chairman, Commissioners. James Greger on behalf of staff. Also present for this item are Ben Baker with Telco Gas Water, Samuel Tito with Engineering Division, and Lucy Shea with Accounting Investigations Division. On July 30, 2021, Artesian Water Maryland filed an application with the Commission for approval to construct a new water system to provide water service to Phase 1 of the Bainbridge property located in AWMD's Port Deposit franchise in Cecil County, and any and all other regulatory approvals necessary to authorize the proposed action. Public Utilities Article Section 1-101 Q defines water company as a public service company that owns a water plant and sells and distributes water for PUA Section 1-101-R defines water plant as the material, equipment, and property owned by water company and used or to be used for or in connection with water service. Under PUA Section 5-204B, a person may not construct a water system for public use without prior commission approval. The standard for approval is a finding that the construction of the water system is in the public interest based on the financing plans and other pertinent facts and circumstances. The burden of proving the project is in the public interest is on the applicant and requires full disclosure to the commission of the applicant's financing plans. Specific application and information requirements for requests to construct water systems are outlined in COMAR Title 20, Subtitle 73. AWMD proposes to construct a 16-inch water main extension from its booster station located on Jacob Tome Memorial Highway to the water tower lot located in Phase 1 of the Bainbridge property. The main extension will cover approximately 10,152 linear feet. The source of water for the water system extension is the Susquehanna River, and the raw water is treated at AWMD Port Deposit Water Treatment Plant to meet requirements of the Safe Drinking Water Standards. AWMD and the present filing request commission approval for construction of the water system for Phase 1 of the Bainbridge property. The application discussed additional obligations because AWMD entered into a memorandum of understanding with Bainbridge Development Corporation, MTPM LLC, and MRPI Bainbridge, such that AWMD will enter into a water service agreement and construct a water system. AWMD's responsibilities are: 1, to purchase and install a water main that will be partially paid for by MTPM LLC and MRPI Bainbridge. 2, fund and upgrade a pumping station to meet the water service requirements of the project, which may change in the future. 3, pay for costs for future water facilities, including connecting a future water storage and water treatment plant. And 4, restore water service in case of unforeseen interruptions and to provide notice of planned interruptions. Based on the application, staff believes that only parts 1 and 4 of the MOU falls within the scope of the requested water system approval requested by the company. Staff believes the company will be required to file a request to construct water systems for parts 2 and 3 when it seeks to complete additional phases of the Bainbridge property. Following its analysis, staff supports the commission providing permission for AWMD to construct a new water system, but the company should not be permitted to recover costs incurred to serve future customer growth if the customer growth does not materialize. The company should be required to track these costs to be available for review if AWMD applies for a rate case. The cost for the excess main and additional water system should not be recovered from ratepayers unless they become used and useful, which can be studied in the company's next base rate case, so long as the costs and their causes are tracked. Therefore, staff approval of the proposed water system extension by AWMD. Thank you, and staff is available for questions.
Thank you, Mr. Greger. We'll now turn to the representative from Artesian Water, Maryland.
Good morning, Commissioners. This is David Spake. I am the Chief Financial Officer for Artesian Water, Maryland. I have with me today Joseph D'Annunzio, who's the President, and Scott Steffen, who is the regulatory analyst. This filing represents the culmination of a long history of planning and processing in the port deposit development, a municipality that we acquired a number of years ago. The Bainbridge development, actually planning for it extended well before our involvement, but recognized that our involvement would bring water supply to this area, which is immediately above the town of Port Deposit that rests on the Susquehanna. This main that we're talking about, though, has been sized to service the entire development and to allow for the expansion of that system in and around the Bainbridge development. We agree with staff's assessment and their letter and recommendation to the commission at this point, and we are available to answer any other questions that this commission may have. Thank you.
Thank you, Mr. Speck. After reviewing staff's buck sheet, it appears that all the necessary protections are in place and staff finds the application compliant. I do appreciate the water utility looking out into the future and recognizing that the size of the diameter of the pipeline, even though not necessary now, may be needed for future development and customers. So I appreciate that. I appreciate the utility financing that at no cost to the ratepayers until such time that infrastructure is used and useful. I do not have any questions for the parties. To my colleagues, seeing none, I would move that we approve the proposed water system extension. The vote begins with Commissioner Herman,
Aye.
Commissioner Linton,
Aye.
Commissioner O'Donnell,
Aye.
and Commissioner Richard.
Aye.
I vote aye. The motion is approved. Seeing no additional business on today's administrative meeting, this meeting is now adjourned. Thank you.
Thank you.